Hi, and welcome to Celebration Bar Review. We're continuing our series of 10 tips on how to improve your bar exam scores, and today's message might be one of the more important among those 10 tips. Very simply, it's to change your perspective. And by changing your perspective, what I really mean is to start thinking like a bar examiner instead of a bar applicant. Now, why would that be so important? Well, the reality is that an awful lot of people sit down and take the bar exam working under false pretenses. They work under a series of assumptions about what the test is measuring, about how the examiners are working, about what's going to happen, that really doesn't bear much reality. It's pretty much a fantasy. As a result, they prepare and they test in a way that doesn't really give the examiners what they're looking for, and then they may not get the results that they want, or certainly not the passing results that they need in some circumstances. And I found that one of the best ways to change that entire process is to change the way you think from a perspective of a bar taker and adopt the perspective of the bar examiner. You see, the bar examiners are not idiots. Neither are they people locked up in ivory towers. Neither are they law school professors, all of whom are interesting, wonderful, worthy creatures, but none of which precisely define a bar examiner. The bar examiners are really charged with something quite different, and that is to determine the applicability of a particular candidate or the worthiness of a candidate to practice law in their jurisdiction. Now notice the term is to practice law. It's not to teach law. It's not to memorize law. It's not to recite law. It's not to vomit on the paper every legal term of art that you can think of. It's to be able to practice law. Now, I know that there are those who say that a test can never measure that, and I would agree that it certainly can't measure one's common sense or one's ability to make good judgments, but it does measure, I think, rather effectively in all of its forms, the ability of an applicant to think like a lawyer and to be able to articulate that thinking or to express it in a variety of different forms. Now, certainly, as a component of most every exam, we've got the MultiState exam, and that's written by the National Conference of Bar Examiners. Now, there are those in my industry who would tell you that the Conference of Bar Examiners are designed and they're out there to trick you, they're out there to get you, they're out there to hurt you. It's silly. I mean, it's ridiculous. They don't have any personal grudge against any applicant. They're not trying to trick people or to create a test that's impossible. Far from it. The MultiState Bar Exam is actually one of the most measurable, definable, predictable tests that I can think of. It's been tested over and over again. It's even standardized against a baseline so that it can be created and considered to be fair. There are 6 subjects in the MultiState, at least right now, and I will say that they're considering adding civil procedure in a year or two. But even when they do that, if it happens, it will come after a long period of discussion and thought and input from a variety of sources. But what the bar examiners, the national conference, is doing is really trying to give you a 200-question multiple choice exam that measures whether an applicant in 6 broad subjects has a basic understanding of the principles of law. Whether or not that applicant can look at a fact pattern, discern what's important, separate out what's unimportant, make a reasoned judgment about the right outcome, and then figure out between 2 answer choices that have that outcome what the correct reasoning might be. Now, does that require that one be able to memorize all the elements of the law? The answer is no. And the reason that that's not important is that it's not a skill that you need in the practice of law. I mean, think about it. Those of you that are practitioners know this already, but those of you in law school, you're in for a rude awakening if you think that when you get out of school and you go to practice law, that you're going to sit around all day saying, now I wonder if I can memorize the elements of the following 4 causes of action so that I can recite them to somebody. I mean, that's ridiculous. It doesn't happen. It's very much an archaic skill to be able to memorize and recite, particularly in the age of the internet and instant resources and LexisNexis and Westlaw and so on. I find it ironic that Westlaw, one of the great providers of legal information, is also one of the owners of a bar exam or a bar review that tells people to memorize. You know, they need to get their act together, I guess. The point is that you don't need to be a memorizer to do well on the MultiState Bar Exam, and anyone that tells you that you do is really just trying to get you off their back so that they don't have to teach you. What you really need to do to be successful in the MultiState exam is to learn basic principles of law and then to learn how to apply them in the fact patterns that you're going to see on the exam. Now, we do that by using licensed questions and writing answer explanations and letting you work through those after you've done reading and listened to lectures on those subjects, and by giving you constant repetition. The point is that when you've done that, now you're starting to give the examiners what they're looking for, which is a very clean, predictable way of evaluating your basic knowledge in 6 basic subject areas. Well, what about essays or performance tests, the state part of an exam? You know, it's really the same idea. The examiners in any jurisdiction that I'm familiar with really are not interested in whether or not you've memorized the arcane rules of their wills and trusts codes, or their procedure codes, or whatever it might be. What they want to know is, can you take a fact pattern, a hypothetical, and discern from that what the disputes and the problems are, the legal problems, and then provide a reasoned solution. Now, it's great if your reasoned solution is absolutely accurate as far as the law goes, but here's a little secret. Hardly anyone knows what the real law is anymore. It's really what 5 justices on the Supreme Court say it is, or what a majority of the state Supreme Court would say. The reality is, no one has a perfect definition of what the law is. The restatements aren't perfect, the codes aren't perfect, they're always subject to interpretation. In the same way, an essay can't be perfect. It can't have the correct black letter rule of law. It's really not a test, again, of how much law you know. It's a test of how you use the law as you know it and apply it to a particular fact pattern. That's why when we teach writing in our course, we teach it on the basis of using facts and making arguments, not on the basis of IRAC writing, whatever that craziness is, or issue spotting, or how many rules of law can I get on a piece of paper in 30 minutes or 45 minutes or an hour. That's not productive writing. No one in the practice of law would even dream of doing such a thing. If you were writing a brief to the court, or a letter to the partner, or a letter to a client, you wouldn't sit down and say, "Dear Client Smith, I've found the following 27 issues that might be applicable to your contract dispute with your landlord." That would be ridiculous. You try to resolve the problem that's in front of you, and you try and do it in an effective and straightforward way. You see, too often when people come to the exam thinking that it's just about how much law they've memorized and how much they can recite, or how many terms of art or legal words they can get down, how many buzzwords they can put in, how many words they can underline or put in italics or put in bold or capitalize, what they're really saying to the examiner is, I don't have any idea what's going on. I'm clueless about what would happen in the real world. I'm just really smart. But here's the thing. We know you're smart. That's how you got into law school. We know you're smart. That's how you got out of law school. We know you're smart. That's why you're practicing law. That's not a criteria to pass the bar exam. The criteria for the bar exam from the examiner's standpoint is, do you have common sense? Can you express what you know? Can you think logically and reasonably and in an organized fashion? Can you work under time pressure? Can you work under emotional pressure? All of those are things that impact your score on the exam, and that's what a good bar review should help you get ready for. Unfortunately, too many bar reviews and too many people in this field think that it's really just a matter of cramming more information into your head and then holding it in, hold it in like holding your breath, and then let it all out on exam day. And you know what happens? Most of those people don't pass. Oh, a few do, and then they come back confidently and say, well, it must be because I knew all the law. No, you just got lucky. You just stumbled over enough things that the examiners threw up their arms and said, okay, fine, you win. But you know, that's not a very good strategy, and it's not a good way to prepare for the exam. If you were the examiner, who would you rather have in your bar? Someone that actually could think logically and in a reasonable, organized fashion, or somebody that was a memorizer and a reciter, a chaotic piece of junk throwing stuff out everywhere? I think the answer is pretty obvious. And so when you're trying to improve your bar scores, think from the perspective of the examiners and what they're trying to get at, instead of the perspective of the applicant who's really not very well informed. When you do that, I think you'll see a big difference in your score and a big difference in the quality of the work that you do. Well, I hope that's helpful, and I look forward to coming back one more time with our 10th in the series. But we appreciate you taking the time to watch and listen, and I look forward to hearing from you soon. Thanks.